Hello, welcome everyone. My name is Rilus Dana. Today we're going to talk about one of my favorite topics, which is estate planning for digital assets and the privacy of your data. So yesterday I attended a CLE, a continuing education course, as attorneys were required to take so many classes a year. So I was taking a course to make sure I'm current. And I'm always looking for different estate planning or interesting topics. So if there's ever anything on digital assets, I've taken just about all of the major courses from the different places. This one is pretty good. The speaker definitely knew her stuff. She's from the East Coast, from Connecticut, and she was actually involved in RUFADA, the Revised Uniform Fiduciary Access to Digital Asset Act. So that's the law that makes it possible to plan for your information. So that was passed in Arizona in 2016 and then in California in 2017. So that's really changed my career. Once that law was passed, it made it possible to do more planning for digital assets. So ever since then, ever since 2016, this is a topic that I've been consuming as much information as I can about it. So let's, I guess before we get into, yes, whenever you go to CLE, these courses, it's either two things. I was just thinking about how earlier in my career I would go and I would learn a ton from each of these places. And now when I go, it's about seeing what's changed or seeing if your current process is working. And so I kind of joke that either you get either you learn something or you get confirmation that you're already doing it right. Or sometimes what happens is maybe you disagree a little bit with the opinion of the speaker in how they're handling things. So there was a couple places where I disagreed, and I feel like it highlighted or it emphasized the three-step process that we're doing through Mott Legal. It just emphasized that is a great process. It does exactly what it needs to do, and it avoids some of these other problems that people are running into. So I guess my main disagreement is kind of the overall style, and some of this comes from what I call just kind of old school attorneys, where they're stuck in things, they're stuck in the more traditional way. They've had more time in their career on that side of things, before the internet and before things got more digital and paperless. But her general approach was to try to give the trustee, make sure you give the trustee enough power in the trust so that they have power over digital assets. And then that brings up the issue, well, do you really want the trustee to have information about all of your life or all of your data, everything you stored electronically? So her solution was in the individual accounts like Facebook and wherever you're storing data, to work with them using their online tools to have your account deleted or shut down if it's something that you don't want shared. So that's a little bit different from the approach that I use. So let me share my screen. We'll get into that. So this is where I practice law in Arizona and California, Dana and Associates. And I've been doing these digital asset trusts for 5 years now, since 2016. So here's a three-part digital asset planning process. You'll see this Mott Legal logo up here. So Mott Legal is also my company, but this is where I share the tools with other estate planning attorneys. So other estate planning attorneys can use this Mott Legal three-step process. I'll actually share a code at the end of this video for attorneys to save $100 on our digital asset planning course, so they can add this to their legal practice. All right, so here's the three-step process: general, specific, vault. There you go, very easy. So what is that? So the general power that I give to the trustees and to agents and powers of attorney, and this language here is actually from a last will and testament. So this is given the personal representatives the ability to get an inventory of digital assets, whether owned in their name, owned jointly with another person, owned by a business. The inventory should be limited to the value of the account, ownership of the account, and named beneficiaries, if any. So the general request, tell the fiduciary about your accounts, about your financial accounts. That's the information that they need. So in my experience, administering trust and estates after someone passes away, the successor trustee or whoever's named in the will is a personal representative. What they're trying to do, one of their first steps or one of the first issues they run into a lot of times is locating the assets of the estate or the trust. So if they can't find information around the house, if you didn't leave good records for them, this general request allows them to call the bank and the different places, and then the bank can at least share that minimum information, let them know if the person that passed away, if they did have an account there. All right, this is the general language in the revocable trust. So as part of our revocable trust, it's very similar language as we just saw, but it's talks about the trustors because this is the trust. And I have them sign specifically on this page, on this schedule, saying that they assign their digital assets to the trust for that same limited power, the power to get an inventory. So that's the general step. All right, this is a digital asset inventory and checklist. This is included in the welcome packet. When I first meet any estate planning client, they get a copy of this along with their fee agreement. And this is the process that I want people to go through. Number one, inventory what you have out there, things that you care about that are stored electronically. Maybe nothing, then you're done. But if there is things that you store electronically that you care about, see if they have what's called an online tool. What that is, that's a way to transfer the ownership of the account or to transfer some information in your account. In Facebook, it's called Legacy Settings. And in Google, it's called Inactive Account Manager. And I heard Apple is releasing, I guess it'd be a more progressive online tool, or they're releasing in their new operating system, there's going to be ways to transfer your data or to give instruction on what happens to your data a little bit more. Now, for accounts that don't have an online tool or they don't have a good one, so like Google, their inactive account manager, it's I don't want to name my 14-year-old son on my account. So in my digital asset trust, I gave the specific instructions. So digital asset trust, you're going to see that's the specific part. That's where we give specific instructions. And then the last thing is you can consider sharing login credentials if not prohibited. All right. Digital asset trust. So this is the specific part. This is where you can leave specific instructions. So as part of our estate plans, we do a separate digital asset trust in addition to the revocable trust. So this is a place to give specific instructions over accounts. So things like email, here's what I recommend. This is the language right from one of my digital asset trusts. It says that the trustee may request a copy catalog of electronic communications for the preceding 12 months. So that's what this is, this catalog of electronic communication. This is defined in that Digital Asset Act, but it's basically a list of information. It's a list of who they had communications with. So not the subject, but just a list of who emails were received from. The idea here is that this will allow a trustee to locate bank accounts and financial accounts. Now, when everything came on paper, before the internet, before email was more popular, the very beginning of my legal career, actually before I was even a lawyer, I worked as a law clerk in a law firm. And back then, more stuff came on paper. So when someone passed away or suddenly became ill, you could start getting their mail to see what shows up. And that was a really good way to figure out what accounts a person had. So in the digital asset trust, what I recommend is listing your email and giving the trustee the ability to get a list of emails received, so that way they can find, bank statements and things that you may be receiving electronically only. And then for media that you store electronically, like the photos and videos on your iCloud account, we can give instructions for those. So this is also language from one of my digital asset trusts. It says the custodian. So we would list the actual email account that's identified with the Apple ID, and then the custodian Apple shall provide a copy of all photos and videos to the spouse and each child of the trust store. All right, so that's how we leave specific instructions, and I feel like this is a really good approach. It solved a lot of the problems that they were talking about in that continuing education course. They're talking about people not getting access to photos and videos after someone's passed away, and how you can't get that information with just some general language in a trust saying that the trustee has authority over digital assets. You have to be more specific on what they can get. And you also want to check to see if that company provides an online tool, a way for you to access it that way. All right, the third part of our digital asset planning process is we provide a way to store everything online. So this digital vault, there's a link here. So all of our estate plans, we pay for the license, and we upload all of the signed documents, all of the PDFs to the digital vault for the client. And then they can decide who can access their vault, when they can access it, and what they can see it. So that's the way that we help people transfer information electronically. Here's our current version of our website. So I'll show you now a cool resource that we have going on here. If you haven't done a will, or you need to update your will, you can do it for free. So there's a link in this video, or you can go to our website, and then this is the link. This is what you'll find. So there's a form here that you can download to do a handwritten holographic will. That's the easiest, fastest way to make a valid last will and testament. So if you don't have a will, go do that. Get that done today. For attorneys, if you want to add this digital asset planning to your practice, I got a code going on the bottom of the screen here. And there's a link in the video to the Academy, the Mott Legal Academy, or you can find it here at mottlegal.com. But here you'll find the estate planning for digital assets course. So this course is $199. There's a coupon code below to save $100. And this includes the templates for the digital asset trust, and all the language that I use, everything that I use to explain this to clients, including that digital asset inventory and checklist that we looked at. This will work in any of the states that have RUFADA, which I think is most all of them now. And if you're not doing this, if you're an estate planning attorney and you're not offering this in your practice, this should be a no-brainer. I'm going to be raising the price of this course soon. It's going to be probably going to go up to like $499. So grab it now with this code below. It's only $100. So thanks everyone for watching. There we go. Thanks everyone for watching. If there's a topic that you'd like to hear about or have questions on, leave it in the comments below. We'll see you next week.